Well, good morning. And before we begin, we encourage you to take a moment to reflect and connect with the land that you are currently on and reflect on who the original occupants were. For the college, we are located in downtown Toronto. Toronto itself is a word that originates from Mohawk word meaning, or Takaranto, meaning the place in the water where the trees are standing. Takaranto and the Ontario College of Teachers are in the dish with one spoon territory. The dish with one spoon is a treaty between Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans, and all newcomers have been invited to join this treaty in the spirit of peace, friendship, and respect. And we're grateful to have the opportunity to assemble with all of you virtually, recognizing that you are participants on many traditional territories across the province. And we're here to work and learn with you to benefit students in Ontario this morning. So welcome. And good morning. My name is Jamie Robertson. I'm the Director of Investigations and Professional Conduct with the Ontario College of Teachers. I want to take this opportunity to thank you for joining us this morning, and we will be discussing a number of topics. One, the sections of the Ontario College of Teachers Act that gives the college's investigations committee, the college's complaint screening committee, the power to conduct medical inquiries where a member may have a fitness to practice question. The section of the Act that requires members to make self-reports to the college regarding certain criminal matters, a refresher on employers' duty to report, including obligations as they relate to fitness to practice matters on the part of members, and an update on the college's therapy and counseling program. I'd like to introduce our presenters for today. Patrick Winter is our Senior Intake Officer. Evelyn Liu is our Intake Coordinator. Janice Duggan is Manager of Investigations. Jeff Steinberg, Investigator. And Lisa DaCosta is an Investigator. College staff will stop the presentation between topics to answer any questions that you may have. They'll also be available at the end of today's webinar to answer questions. In addition, the information presented today will also be available on the college's website. To support you moving forward, we will provide you with a copy of the slides and a link to the recording to this webinar by email in the coming weeks. So with that, let's get started.
Hello and welcome everyone. On the slide is a list of the topics we will be speaking on today. Medical inquiries process, changes to the Ontario College of Teachers Act, self-reporting, employer reporting obligations, and an update to therapy and counseling. We are beginning today's presentation with some slides regarding relatively recent changes to the Ontario College of Teachers Act that give the Investigation Committee the authority to conduct medical inquiries regarding members who may have a fitness to practice issue. I should note that during today's presentation, we will use the terms capacity and fitness to practice interchangeably. Both terms refer to a member's ability to fulfill their professional obligations as a teacher. Effective February 1st, 2021, the Investigation Committee was given new authority to make medical inquiries regarding a member who may have a fitness to practice issue. We will now outline how this process works.
So to begin, when the college receives a complaint from an employer or a member of the public, the information is reviewed by a college investigator in conjunction with the manager of investigations or the senior investigator. If the information received indicates that there may be a fitness to practice issue, the matter will be taken to the college's investigation committee for its review and consideration. The above slide sets out the factors that the college evaluates in order to determine if the matter may warrant the investigation committee making medical inquiries.
Under this power, when the investigation committee reviews information relating to a member and they believe that the member may be incapacitated, they shall make inquiries regarding the member's capacity. This is the first step in the inquiries process. This authority is set out in section 26, 4.5 of the Act. The threshold to make those inquiries is very low, only requiring that the investigation committee believe that the member may be incapacitated.
So Lisa, what is the object of the medical inquiries process?
The object of the medical inquiry process is to identify and resolve capacity matters at the investigation committee stage. Prior to the change to the Act, the only way to resolve capacity issues was a referral to the college's Fitness to Practice Committee for a hearing. If the Fitness to Practice Committee determined the member was currently suffering from a physical or mental condition or disorder, such that they are unfit to carry out their professional responsibilities, the panel may, among other things, direct that the member's certificate should be made subject to terms, conditions, or limitations. The investigation committee's medical inquiries authority allows the committee to resolve capacity matters at the investigation stage, which means no Fitness to Practice Committee hearing is required. The slide on screen sets out the section of the Act that gives the investigation committee the authority to begin the medical inquiries process. As Jeff noted, the standard for the investigation committee to make such inquiries is very low. It's only the belief that the member may be incapacitated.
Okay, so the above slide sets out section 47.1 of the Act. This section is not part of the medical inquiries process, but it is related because the section sets out the college's authority to obtain medical information about members from employers. As will be discussed later in the presentation, part of the medical inquiries process requires the college to ask employers for medical information about members. Pursuant to section 47.1 of the Act, the college is entitled to obtain medical information, and that information is vital in medical inquiry files. Section 47.1 of the Act permits the college to request personal information, including medical information about members is defined under provincial and municipal freedom of information legislation. The college will ask for and is entitled to receive medical information, including psychiatric, psychological, or counseling information regarding a member who is the subject of the investigation committee's inquiries. The next slide sets out the applicable privacy legislation referred to in section 47.1.
So Jeff, before we get to the next slide, what steps does the college take to protect medical information?
Well, firstly, under section 48.1 of the Act, all college staff and members of college committees, including the investigation committee, are required to keep all information confidential and not communicate the information to any other person subject to certain exceptions. As well, when panels of the investigation committee write their decision and reasons, particularly in public complaints, sensitive personal information, including medical information that relates to a member, is referred to in a generalized manner so as not to disclose the particulars of the information. If the member or the employer provided medical information that was particularly sensitive, the information would also be referred to in a general manner.
The Ontario College of Teachers Act specifies that the college can require employers to send personal information to the college as defined in the Municipal Freedom of Information and Protection of Privacy Act and the Freedom of Information and Protection of Privacy Act. These two privacy acts define personal information as including information relating to the medical, psychiatric, or psychological history of the individual. As noted earlier, this information is particularly important when providing information relating to medical inquiries. It is also important when making a report to the college where the employer is of the view that a member may have capacity issues. We'll touch on the fitness to practice reporting issue later in the presentation. We're going to pause here and break for questions. If you have any questions about any of the information so far, please type them in the chat. Under the medical inquiries process, if after reviewing all of the information gathered to date, the investigation committee believes that a member may be incapacitated, it directs the assigned investigator to make inquiries about the member. This is where the employer comes into the process. As part of those inquiries, the investigator will write to the member's employer asking for any information regarding the member's health that has not already been disclosed to the college. At the same time, the investigator will also make the same inquiry of the member, or if they're represented, their counsel.
So what happens after the inquiries are made? The slide on screen sets out the legislative authority for the investigation committee's next steps in the medical inquiries process. When the information from the member and the employer is received, the next step in the medical inquiries process is that the same investigation committee panel that directed the inquiries meets again and reviews any new information that was obtained. After reviewing all the information, the investigation committee then has to determine if it has reasonable and probable grounds to believe that the member is incapacitated. Reasonable and probable grounds is defined as more than a mere suspicion. If the investigation committee panel decides it does not have reasonable and probable grounds to believe that the member is incapacitated, the inquiries process is at an end and the regular investigation process will continue. If, however, the investigation committee panel determines that it has reasonable and probable grounds to believe the member is incapacitated, the panel can still refer the matter to the Fitness to Practice Committee under Section 26(5)(a) of the Act, or require the member to submit to physical or mental examinations.
In most medical inquiries cases, the investigation committee panel will have the member undergo physical or mental examinations. As set out on the slide that is on the screen, the physical and/or mental examinations will be conducted by an independent health professional specified by the investigation committee. The college bears the expense of the independent medical examination.
So if the investigation committee determines that a member attend a medical assessment, two things may happen. First, the member may not agree to attend the assessment. If the member does not agree to attend the medical assessment, the investigation committee may make an order directing the registrar to suspend the member's certificate. This authority is set out in Section 26(4.7)(b) of the Act on the slide above. Before the investigation committee makes such an order, it must give notice to the member of its intention to direct that the member be suspended. And the member must be given an opportunity to make written submissions regarding those intentions. The next slide sets out the legislative requirement to give the member notice and the opportunity for them to make written submissions.
As Jeff noted, the slide on screen sets out the legislative requirement regarding notice and written submissions. The slide on screen is Regulation 61620. That regulation provides the member with at least 14 days to make written submissions as to why the investigation committee panel should not direct the registrar to suspend the member's certificate.
Now, I mentioned earlier that there were two potential outcomes after the investigation committee directs a member to attend a medical assessment. So we just covered the first outcome, what happens if a member declines to attend. The second outcome occurs when a member attends the medical assessment. If the member agrees to the medical assessment, the member is provided dates that the independent medical assessor is available and an appointment is scheduled. Assuming the member attends and fully cooperates with the medical assessor, the assessor prepares a report. The report sets out whether the member is incapacitated, the extent of the incapacity, and the prognosis for recovery, which may include compliance with medical treatment and other terms or conditions. The report is provided to the investigation committee, the member, and/or the member's representative.
After reviewing the medical assessment report, the investigation committee panel may determine that there are no current capacity issues. If that's the case, the medical inquiries process is at an end. At that point, the investigation committee panel prepares a written decision and reasons regarding the medical inquiries process. The decision and reasons are sent to the member or their representative. At that point, the investigation committee panel asks the member for their submissions regarding any allegations of professional misconduct in the complaint, and the investigation process will unfold as it normally does. If, however, after reviewing the medical assessment report, the investigation committee panel may determine that there are capacity issues. In those cases, the medical assessor will have provided suggested terms, conditions, or limitations that would need to be placed on the member's certificate in order for them to be able to teach. In such cases, the member or their representative and college staff or council will negotiate an undertaking that would include appropriate terms, conditions, or limitations to be placed on the member's certificate.
Now, it is important to remember that the investigation committee is not an adjudicative committee like the fitness to practice committee is. So what does that mean in the context of considering an undertaking regarding a member's capacity? It means that while an investigation committee can consider and adopt an undertaking that has been negotiated by a member or their representative in the college, it cannot tinker with or change the terms of that undertaking. A fitness to practice committee can make such changes within certain limitations. So, under the medical inquiries process, appropriate terms, conditions, or limitations can be negotiated at the investigation committee stage. But the investigation committee panel that considers the undertaking may only adopt the undertaking or reject the undertaking. It cannot make changes to the undertaking.
If the member and the college cannot agree on the terms of the undertaking, the matter would be brought back to the investigation committee panel. At that point, the most likely result would be that the matter would be referred to the Fitness to Practice Committee for a hearing. If, as Jeff has noted, terms, limitations, and conditions have been negotiated and incorporated into an undertaking, the undertaking is presented to the investigation committee panel, which can adopt the undertaking or can reject the undertaking. As with all employer reports to the college, the employer will receive the investigation committee panel's written decision if the matter is referred to the Fitness to Practice Committee, or if the undertaking is adopted, the panel's written decision and reasons. We are going to pause here and break for questions before we move to a new topic. If you have any questions about any of the information so far, please go ahead and type them in the chat.
So there are a few questions that have come up in the chat. The first one comes from Tammy, who asks, is there a definition for incapacitated?
Sorry, perhaps I'll take that one. It's Janice Duncan speaking. Yes, there is a definition in the Ontario College of Teachers Act that sets out what in terms of what the investigation committee would be looking at. It's section 31 sub 2 of the Act, and it basically says the member is suffering from a physical or mental condition or disorder such that the member is unfit to continue to carry out his or her professional responsibilities, or that a certificate held by the member under the Act should be made subject to terms, conditions, or limitations. So that definition is set out in the legislation.
Great, thank you, Janice. And there's a follow-up question from Tammy. Can this type of investigation be initiated by parents, or does it have to be by a school board?
It is most likely that this type of investigation would be initiated by an employer. However, there are instances, and it would be available to a member of the public to make that type of allegation with respect to a member.
Thank you, Janice. And there is another question from Michelle. When members are required to provide medical updates, how does the school board know that these requirements are being met?
If I understood the question, and maybe we can get some clarification, but if you are referring to the fact that they may have to fulfill terms, conditions, or limitations through an undertaking, or at the fitness to practice level, the college would monitor that, and you would be aware of the conditions. And if there were a breach of the conditions, a new investigation would be initiated. I hope that addresses the question.
Thank you, Janice. So basically, we're not updated as to whether or not the conditions are being fulfilled, but we would know if they haven't, because you would initiate a new investigation.
Right, the member, when they enter into an undertaking, or if it's a fitness to practice order, if there's a breach, the college would initiate a new investigation. In terms of updating you, I don't think that would be something that the college could proactively do. But if there were a new investigation with respect to a breach, it's quite likely that the college would be asking the employer for information relating to the member's current ability to teach, for example.
Okay, thank you.
Thank you, Janice. And there is one more question from Rosemary, who asks, what is the timeline for the investigation to complete?
So the medical inquiries process, as you may have gathered from so far in the presentation, it's a 3-step process. And we do, for reasons of procedural fairness, provide timelines for the member to provide additional medical information. We try to, if it's going to resolve at the investigation stage, we try to do it within a year, but sometimes that will be subject to obtaining additional medical information from the member. Sometimes it'll be if the employer is trying to give us additional medical information with respect to the inquiries process. And sometimes it's a scheduling matter of having the same 3-member panel attend on different dates to consider a matter. But we do try to, as with all complaints, we do try to resolve them as quickly as we can within the resources that we have.
Thank you, Janice. And there was one more that came in from Vicky, who asks, is there a timeline when a complaint needs to be filed if there's a belief that the member is incapacitated?
Patrick, did you want to take that one?
Sure, I can jump in there. There's no legislated timeline for the submission of any sort of complaint or any sort of report, apart from the necessity to report certain matters under sections 43.2 and 43.3 of the Act within 30 days. I may throw it back to Janice a little bit here, because she has more expertise with respect to the actual investigation committee outcomes. But my perspective on this would be that a complaint, or if it's coming from an employer, a report should be filed as soon as possible when there is a belief that the member is incapacitated, both in respect to a public protection piece, as well as fairness to the member, as well as we certainly would want the report to be submitted when that incapacity is a concern. If it's something that has occurred in the past and is no longer a concern, I don't know that there would be the need to report that. Janice, do you have anything else that would be necessary with respect to sort of investigative procedures about that question?
Yeah, I think I would echo Patrick's comments and reiterate that it is important to remember that for the purposes of a finding of incapacity by a college committee, it is the member's current capacity. So is the member currently unable to fulfill their professional duties as a teacher? So as Patrick noted, if there is a concern about the member's capacity that has arisen, it would be important to report that as quickly as possible. There's no deadline or timeline in the act for that, but it would be of assistance because of the nature. It has to be current for that finding to be made. So if something, as Patrick said, had happened in the past, but the member no longer was exhibiting whatever the issues might have been, then it's less urgent, obviously, and it might not even be appropriate to report it as a fitness matter.
Great, thank you, Janice and Patrick. There is a follow-up from Vicky. And I'm not sure if this is for us, but I'll share the question here. Is the member paid by the board during the investigation process if on home assignment while the board has been doing their due diligence and trying to get medical and work through their own investigation?
The way that's phrased, it does sound like it's more of an employer question as opposed to a question fielded by the college, unless Patrick has something to add.
No, I would echo that it's likely something that would be agreed upon through the contract that is in place between employer and employee. Typically, if the college may, in certain very limited circumstances, suspend an individual's teaching certificate pending the outcome of an investigation. I don't know if that's a common thing to do during an investigation into an individual's capacity, but if there are no restrictions put in place pending the outcome of a college investigation, the college's position is that the individual is eligible to hold a certificate. Anything beyond that would be a discussion between the employer and employee, as well as various representatives, as would apply.
Great, thank you again so much, Patrick and Janice. Those are all the questions we have so far. So we'll continue on with the presentation.
All right, thanks, Ryan. And we're going to switch gears entirely now and discuss a fairly new change to the Ontario College of Teachers Act about the duty of members to self-report. Now, this slide outlines relatively new legislation regarding a member's duty to self-report in relation to criminal matters. Bill 229 amended the Ontario College of Teachers Act to include these new reporting obligations for college members who are subject to offenses, charges, bail conditions, or other restrictions. These reporting obligations took effect on December 8, 2020, and failure by members to comply with these reporting obligations may be considered to be professional misconduct. Now, again, you'll see the reporting obligations listed here if a member has been charged with an offense. When self-reporting, the member must include, among other things, the charge, when the charge was laid, and the location of the court in which the charge was laid. All bail conditions or release conditions should be included in the report, as well as the status of any proceedings. Now, we provide the opportunity to members to make these self-reports online through a web form that's available to them, and that's how we receive the vast majority of these reports. As an employer, it's important to remember that you should continue to report criminal charges or convictions to the college, as the employer does have these duties to report charges and outcomes under the Act. And as you can imagine, some members may not fulfill their obligation to self-report criminal charges or criminal convictions. Aside from fulfilling your reporting obligations, it is important that you make these reports because the college is mandated under the Act to post criminal charges, bail conditions, and release conditions that restrict a member's eligibility to teach, and to post criminal convictions. The college's mandate is to govern the profession in the public interest and to protect students. Posting a member's criminal charges, applicable bail conditions, and convictions helps the college to fulfill its mandate by alerting the public to members who may pose a risk to students.
All right, thank you, Patrick. The next few slides will lay out the statutory framework which governs your reporting obligation to the college as an employer. The duties include an ongoing obligation to provide documentation as well as information to the college within the specified time frame. Some fun fact, in a typical year, the college receives about 400 employer reports under Section 43.2 and 43.3 of the Ontario College of Teachers Act. I'm going to direct your attention to the slides on the screen. Section 43.2 of the Act says that if you terminate, suspend, or restrict the duties of a college member for reasons of professional misconduct, then you must notify the college in writing within 30 days. And you must report this even if the member resigns while you're conducting an investigation or compiling evidence. I will circle back to what constitutes a restriction of duty later. Section 43.3 of the Ontario College of Teachers Act says that if an employee or former employee is charged with or convicted of a criminal offense involving sexual conduct and minors, or an offense that in the opinion of the employer indicates that students may be at risk of harm or injury, then the matter must again be reported to the college within 30 days. This section is pretty self-explanatory because it sets out various scenarios relating to the duty to report relating to certain types of criminal charges and convictions. And please note that this section is written in such a way that employers must report members to the college if you become aware of these charges or convictions, even if the member no longer works for the employer. So this also applies to former employees. All right, so we all know what constitutes a termination or suspension of a member, but questions usually arise around the area of what constitutes a restriction of duty. We provided some common examples, which includes removing a member from an occasional teachers list, a transfer of a member to another school for disciplinary reasons, or blocking a member from teaching specific grades or courses, etc. Section 43.3 of the Act also states that if a member has engaged in conduct or taken action that, in your opinion, as the employer, should be reviewed by a committee of the college, then you should submit a report. This is what we call a catch-all provision, where essentially, when in doubt, then please report this to the college. In addition, we would like to remind you that you are obligated to provide a copy of your notification letter to the member at the same time you notify the college. In the past, the college has been asked whether we notify employers of public complaints. So under the Act, the college is only required to report the outcome of the investigation to employers. However, in most cases where matters are fully investigated, the college will be requesting information from the employer, and in doing so, you will be made aware of public complaints against members at a much earlier stage in the process. Section 277.4 of the Education Act says that if you terminate a member's employment following an unsatisfactory teacher performance appraisal or TPA, then you must submit a complaint to the college. And this again applies if member resigns while on review status during the TPA process as well. Now we're going to talk about what are some of the information that should be included in an employer report. We're looking for name and college registration number of the member, summary of events that led to the report, specifics of disciplinary action taken by the employer, and here we wanted to stress the importance of providing sufficient detail. Going back to the second point, summary of event that led to the report. What we're looking for here is enough information that the college is able to make an initial recommendation as to whether an investigation at the college is necessary. We're looking for a description of event or events that led to the employer discipline and not just a general form letter information. For example, rather than saying the member used inappropriate language, it would be useful to know exactly what the member said. And if necessary, the college will, of course, follow up with you to get further information, but ideally, we're looking for some more detail in the initial report to help us make that recommendation. If we look at this slide, we've included sort of a don't do this and do this instead comparison. So instead of saying John Doe was suspended for 2 days for inappropriate communication and inappropriate physical contact involving a student, here not a lot of detail is given. We don't know what the member said and we don't know what constitute the inappropriate physical contact. We're hoping for the other example instead that John Doe was suspended for 2 days for grabbing a student by the arm and dragging the student out of the classroom. He called the student stupid and yelled at the student to shut up. Here we have a lot more details so that it will help the college make that recommendation as to whether a transfer to investigation would be warranted. Now, how to submit a report to the college. You can either submit your employer report via email at ih@oct.ca, which we will prefer, but you're of course welcome to submit it via physical mail at our physical address as well. If you report by email, please note that it is not necessary to send an additional identical hard copy to the college. If you wanted to ensure that we have received your report, then you can ask in your email that college staff acknowledge receipt of your email, which we're happy to do so.
All right, thanks very much, Evelyn. Moving on, we would like to remind you that the college now has a new fillable employer report form. I know that some of you are using this already, and we've found it to be very helpful for our initial reviewing purposes. The college's Investigations and Hearings Department routinely looks for ways to make the reporting process easier and more efficient for employers of Ontario certified teachers. The new fillable employer report form provides an outline of all the information that's required by the college when an employer submits a report. It can be completed and submitted to the college along with any necessary supporting documentation to ih@oct.ca whenever a report is required. Please note that it is not necessary to use this new fillable form. It is simply being provided for your convenience should you wish to incorporate it into your existing reporting procedures. If you have any questions about this form, or if you would like a copy of the fillable form, you can contact the college's intake unit at ih@oct.ca, and we would be glad to assist you.
Thank you, Patrick and Evelyn. So we're now going to turn our minds to what happens if the matter moves forward to investigations. At that point, you will receive a letter and a checklist asking for further information relating to the report, and also the member's discipline, conduct history with the employer, and we'll speak more about that later point in a few minutes. You're required under the Act to provide the college with all documentation relating to your report within 30 days of submitting your report to the college. So we suggest that you start assembling the information immediately following your report to the college in order to meet the 30-day timeline. When there are delays in providing the information with no notice or explanation for the delay provided to the college, or there's general unresponsiveness, the Director of Investigations and Professional Conduct or the registrar may contact the employer's Director of Education or equivalent at a non-publicly funded school. Now, the college does recognize there will be occasions when providing the information within 30 days may not be possible. If that is the case, please contact the manager in investigations whose contact information is set out at the end of this presentation to discuss an extension. So let's do a quick review of the documents required by the college following an employer report. As noted, the college requires information and documentation pertaining to a member's previous disciplinary and conduct issues. So why do we ask for that information? Well, sometimes when employers are reviewing a member's history, they discover that a matter that should have been reported to the college was not. For example, a member was suspended, but through an oversight, the matter was not reported at the time. This is an opportunity to alert the college of that prior suspension. Sometimes a member's prior conduct issue did not lead to a mandatory reporting obligation, but in light of the current report, it may represent a pattern of conduct. The college is attempting to get the complete picture regarding the member in order that the investigation committee may make a fully informed decision.
Jeff, when the college asks for the information regarding a member, what would that information typically include?
Well, that's a good question. We are seeking all underlying investigation information and documentation, such as principal, vice principal's investigation notes, witness statements, including those of any alleged victim, investigation findings, reports, disciplinary letters, all relevant correspondence, including email, text, or social media messages. Each case will yield different information that was gathered during an investigation, depending on what the allegations were. But what I just listed is typically found in all investigations. The college also requires the member's current employment status and the dates of changes to their status. For example, has the member retired from the board? Has the member gone on a medical leave? The names, addresses, and contact information for school and board staff who were involved in the investigation, and those of any affected students and student witnesses are also required. Please do not send the college redacted documents. If the matter is referred to investigations, the assigned investigator will redact the documents as appropriate before they are disclosed to the member who is the subject of the investigation. If redacted documents are sent, this will lead to the investigator sending a follow-up inquiry seeking the unredacted materials. Now, under the Act, any information that an employer provides to the college must also be provided to the member who is under investigation. So if you have questions or concerns about sending unredacted materials to the member who is the subject of a report to the college, you should consult legal counsel for advice. For TPA matters, the college will require a copy of all summative reports for the member and all materials relating to the TPA process, such as the principal's observation notes and improvement plans.
I just want to add that you may wish to go to the employer's area portal on the college's website, where you can obtain further information concerning employer obligations. Also, most of you are probably aware of the checklist that you receive when the college acknowledges receipt of your report and writes to ask you for information regarding that report. The checklist sets out what documentation the college is requesting from you. If you are not familiar with the checklist, please send us a note in the chat and we will get back to you with the information.
And I'm just going to add at this point that as noted, when you receive the checklist, we ask for the members' discipline conduct history. And often in response to that request, we receive only the letters associated with the measures taken against the member. That is helpful, but just as we would with a current report regarding a member's misconduct, we would also like to receive any underlying information, as Jeff just spoke about, related to any historical matters. So basically, we're asking for the same information that we would expect to see in a matter being reported to you by your obligations under the Section 43 of the Act.
Note that any information you send to the college as a result of the checklist or as requested by the investigator must also be provided to the member within 30 days of sending it to the college. This is a statutory obligation with which all employers must comply. As noted, if you have any questions or concerns about sending unredacted materials to the member who is the subject of a report to the college, you should consult with your legal counsel for advice. Now, once you have provided all of the information identified in the checklist within the 30-day timeline, the investigator will determine if any additional information is required. As indicated in the slide before you, the Act requires that such information be provided within 15 days of the employer receiving the second request. As noted earlier, it is important and appreciated if employers advise if they will be unable to meet a deadline. There may be a good reason to request an extension, and the college is open to considering such requests. If you encounter any issues meeting the 15-day deadline for additional information requested by the investigator, please contact the investigator assigned to the investigation to discuss an extension. The college wants to keep the lines of communication open, so please do contact us if a problem arises with the timelines.
Okay, frequently asked questions. So we will now address some of the most common questions the college receives regarding our requests for information. The college is often asked if audio and video materials should be sent. The answer to that is yes. Any relevant audio and visual recordings must also be provided. For example, this would include video recordings of a hallway incident or a video received from a student in relation to an incident involving a member. The college is also asked about notes and what is required. The college requires any notes, handwritten or typed, related to the report, such as the opportunity to respond meeting notes, interview notes, principal's notes, vice principal's notes, etc. Please ensure the notes are dated and it is clear who authored the notes. Regarding interview notes, prior to commencing an interview, please be sure to include for each set of notes the author and title of the person taking the notes, the full name and title of the individuals present at the meeting or interview, the date, meaning the month, the day, the year, and the start and end time of the meeting or interview, the location of the meeting or interview, the subject matter of the interview. So please make it clear what incident or incidents you are discussing. Please also identify the date of each incident in question. This includes the month, day, and year. If the reported conduct occurred over a longer time frame, please identify the date as best you can, or include a broader time period, such as in or about the spring of 2021, or in or about March 2021. And as mentioned, we would appreciate typed notes. If that is not possible, please ensure legibility.
We would like to take a moment to discuss documents which are sent to us in the form of screenshots. We often receive screenshots of electronic exchanges, for example, email threads, text messages, and social media messages with information missing. Please be sure to identify how the screenshot came into your possession. So for example, on October 1st, 2022, a student named Jane Doe showed the school principal text messages she had exchanged with her teacher, John Smith. On October 2nd, 2022, the school principal took pictures of the screen of Jane Doe's phone, which displayed those text messages. Please note that settlement agreements between employers and members will often contain a provision indicating that the agreement can be disclosed if required by law. The Ontario College of Teachers Act is a law that requires that this information be disclosed to the college. Please also note that employers cannot enter into an agreement, including minutes of settlement, with a member which includes an undertaking that is contrary to your reporting obligations under the Act. So for example, employers cannot agree not to report a matter that is required under the Act to be reported to the college. Also, in settlement agreements, employers cannot agree not to fulfill its obligations to provide information to the college in relation to a report to the college. Your reporting obligations under the Act cannot be contracted out of, so any settlement agreement that agrees to remove an employer's reporting obligations to the college is invalid. So while you as the employer may have settled a matter with a member by having, for example, the member resign from their employment, this does not end the employer's obligations to the college. And finally, please do not write to the college to advise that a matter between you as the employer and the member has settled and you are requesting that the college close its file. The college will not do so. Under the Act, the college has a public interest mandate to govern the profession, and part of that mandate is to investigate allegations of professional conduct, incompetence, and fitness to practice.
Okay, some additional frequently asked questions. We're often asked about what information should or can be redacted from documents sent by employers. So when the college requests information from employers, it is essential that we receive the information in its truest form without redactions. Oftentimes, we receive employer information with students' names, ages, and grade levels and contact information redacted. We also receive employer information that has the contact information about the parents of the student witnesses, redacted if the student witnesses are minors. So I know I'm repeating myself, but please only send unredacted documents. We do require this information for the purpose of our investigation. Now, additionally, the college sometimes receives employer information without the student witness contact information. So please ensure that the contact information is included. There may be a reason for contacting the students during the college investigation, so that information is important. Now, some employers have voiced concerns regarding confidentiality over this type of information. We want to ensure you that this information remains confidential. Contact information is redacted from disclosure made to the member. The college does not disclose student witness and/or student victim contact information. However, we do disclose student witness and alleged victim names. Why do we do that?
We do that because the college has a disclosure obligation to the member during the investigation process. As a matter of law, the member is entitled to have all of the relevant information in order to provide a response to the complaint. When conducting an employer investigation, please do not give members and/or any witnesses assurances of confidentiality. You will be required to provide the college all interview notes and contact information as part of your statutory duty to provide information to the college. As noted, the college is obligated to disclose all information to the member during the course of its investigation. Therefore, any assurances of anonymity should not be given to a witness or an alleged victim. Without that information, a member may be able to argue that he or she could not fully respond to the complaint. The college has received questions about sending password-protected documents. Please do not send password-protected documents to the college. The college email system is secure and confidential. As stated earlier, the college does not require a hard copy of employer information packages. The college's strong preference is to receive an electronic version of the employer materials. Also, please ensure that the documents that are sent are clear and legible. Also, please note that the timelines specified in the Act remain the same regardless of your academic calendar or closure period.
So Lisa, what happens if there's an ongoing grievance or arbitration for the member?
Legislation does not allow the college to delay an investigation when there is an ongoing grievance or arbitration. The employer discipline process and the college's investigation process are two separate processes. While we may follow up with you to determine the status of a grievance, that is to ensure that all of the up-to-date information has been gathered for the investigation committee.
Thank you, Jeff and Lisa. We're going to look at some of the frequently asked questions relating to the employer's duty to report. Number one, do I have to report when an employee goes on the medical leave of absence? So in and of itself, the answer is no. An employer's reporting obligation under Section 43 of the Act, as we've discussed before, are triggered due to a suspension, restriction of duty, or termination of a member's employment for reasons of professional misconduct. Where a member goes on a medical leave of absence in the course of an investigation and you're uncertain whether the member's conduct constitute professional misconduct, then we would encourage you to report the matter to the college. The second question, which I did see one in the question, hopefully this will answer it. Do I have to submit a report to the college when the member is assigned to home pending the outcome of an investigation by the employer? Again, the answer is no, it is not necessary to report that the member has been assigned to home pending an investigation. However, if and when the investigation concludes and the member faces a disciplinary restriction of duty, as we have defined previously, then the matter must be reported to the college at that time. If an employee goes on medical leave during a board school investigation regarding their conduct, am I required to report this to the college? As we mentioned previously, it may be helpful and it may have relevance to how the investigation committee chooses to deal with the member. So we would encourage you to report it to the college.
Okay, regarding the second question on the slide, what is the employer's reporting obligation when a third-party investigator is hired to conduct an investigation of a member. So I'm going to read from the slide. The college receives employer notifications where a third-party investigator has conducted the investigation. In some of those situations, the employer has entered into an agreement with the third-party investigator that permits the investigator to have ownership of its underlying investigation product. While the employer will provide the third-party investigator's final report, it is not able to provide the underlying investigation materials, for example, interview notes, because of the agreement signed with the investigator. So the difficulty for the college with not having the underlying investigation materials is twofold. Firstly, the member who is under investigation may argue that they are not able to provide a full response to the allegations. And secondly, the investigation committee panel that considers the matter may not have all the information necessary to make a fully informed decision.
Great, thank you very much. The college has recently introduced a program to help defray the costs of therapy and counseling borne by students who allege having been sexually abused by teachers involved in child pornography or a prescribed sexual act. If a student has been sexually abused or was the subject of a prohibited act by a member of the college, help is available. Victims, parents, guardians, and siblings can apply for funding to help pay for some of the costs of therapy and counseling. The Ontario College of Teachers will make funding available to help cover victims' costs for therapy and counseling. Approximately $17,000 can be claimed. The amount is equivalent to what the Ontario Health Insurance Ontario Health Insurance Plan would pay for 200 half-hour sessions of individual outpatient psychotherapy with a psychiatrist. It is important to note the college previously communicated that this program was available only to victims in cases where the alleged conduct had occurred after the implementation of the program on January 1st, 2020. This requirement has since been removed and victims are encouraged to apply to the program regardless of when the alleged conduct occurred.
All right, so I just want to check, and we're going to be inviting questions at this time. Would like to check our chat and see where we're at with our questions. I'm seeing a question about minutes of settlement and sharing minutes of settlement, and the question of a violation of the minutes of settlements. And then I see it says found it. So I'm wondering if the question has been answered or if you've answered your own question in that regard. But I will make the comment that when entering into minutes of settlement, it obviously would be important for the employer to consider what it is able to provide in terms of offering guarantees and release with regard to its legal obligation to the college in terms of duty to report. So I don't know if that answers the question. Perhaps Janice might have something else to add to the question and the response.
I think the answer may be in the response found it. As stated earlier, the Ontario College of Teachers Act is a law that would require the disclosure of that information. So the exception in the minutes of settlement says one of the exceptions is that it's required by law, and the governing act for the college is such a law.
Thanks, Janice. And then the next question is, so if witnesses choose not to be named, the employer is required to respect that. Hence, I can't see why there are, with regard to redactions, I can't see how privacy law is trumped by OCT's authority. Janice, you want to respond to that?
I think what Michael is expressing is that during particularly harassment investigations, we will see this, that if people work together as colleagues, they don't wish to be named in the usually external investigation undertaken by a board with respect to that type of complaint. What we are asking is, we understand it's difficult, particularly in sensitive types of cases like harassment, not to provide the witness, or not usually the alleged victim, but the witness or witnesses' anonymity. We're just indicating that does present problems for the college and its investigation, because at some point in our process, we have to provide the member with disclosure. And without the underlying information, the member may be able to say, well, I can't fully respond to this complaint because I don't even know who these witnesses are. It's a tug and pull between the two processes. We're just indicating the difficulties it presents to us. We can't make you not offer somebody anonymity to proceed with an internal board investigation, but we're indicating the difficulties it presents for the college vis-a-vis fairness to the member, because often with harassment complaints is where this usually comes up. Often the board does not disclose the final report to the member. They simply advise the member of the outcome, the findings. But in our process, we require more information than that. So I'm alerting, or I'm not, we are alerting employers of the difficulties that poses for a college investigation.
Thanks very much, Janice. And Michael, if you are looking for further clarification, maybe if you can put that into the chat. And Tammy has a question. Is there a penalty for missing the 30-day deadline? Patrick, can you respond to that?
Sure. The 30, there are penalties in the legislation, I believe, if there are egregious sort of failures to comply with the act. However, it's not something that the college is really necessarily gung-ho to pursue. We understand that delays occur sometimes, and we ask that you do abide by the 30-day timeline for reporting matters as much as possible. It's important for us to get started on our work as quickly as possible. But no, there's no sort of penalty that's enacted at day 31 if the college doesn't receive it. If there is a delay, if you do need extra time, we would prefer that you reach out to us directly to let us know. And again, just we hope that timeline can be abided by. If not, please keep in touch with us.
And I would add, Patrick, my understanding is the college has followed up with individual boards where there's been perhaps a pattern, or the obligation hasn't been met. And it seems to be more than an oversight. There's been some follow-up that's occurred. Great. Thanks, Patrick. All right. And I see we've answered Michael's question. So I'll say at this time, as noted earlier, to support you moving forward, we will provide you with a copy of the slides and a link to recording of the webinar by email in the coming weeks. We'll also include a link to the online survey in the email. Please feel free to complete the survey, as your feedback is important to us and will assist us in planning future webinars. We can take any final questions at this point, if there are any.
Jamie, if I can interject, there were a couple that were sent through a bit earlier in the presentation from Melanie. If you can scroll up to those. So Melanie asks, where an employer reports a criminal charge and the fitness to practice committee issues a decision and later the member is found guilty of the charges, does the employer report the charges? And then there's a follow-up from Melanie as well, right after that. Does the employer report the guilty verdict even if they already reported the original charges?
So I'll turn to Patrick, but just before he speaks, I think any helpful information the college is wanting to receive. Patrick, any additional comments?
Really, just I'll piggyback off of that. The college would want to be informed of the criminal conviction, even if the charge has been provided to us as part of an initial report. The reason for that, our investigators, of course, monitor the proceedings of any matter that has come to our attention. That said, the sooner we become aware of an outcome, the sooner we're able to move forward with it. It won't, of course, result in a new investigation being opened, and typically you'd be able to communicate this information directly to the investigator who's assigned to the file, just in an email format, a very quick note. But the short answer would be yes, we would want to be informed of that.
Thanks, Patrick. And Ryan, any other questions that I've missed?
There just was one from Katie, but I believe Evelyn may have touched upon it. I'll just read it out loud in case there's any additional information needed. Katie asked, does assigning a teacher to home qualify as altering duties and requires reporting to OCT?
And I think Evelyn pointed out in the frequently asked questions that when it's a non-disciplinary assignment to home pending an investigation, there is not a duty to report. But should, after the investigation is complete, it be converted or there be additional requirement, assignment to home or change to duties, then that would require an report to the college.
Great, thank you, Jamie. That's all the questions in the chat.
Great. Okay. So again, if you have any questions following the webinar, please feel free to contact Patrick Winter or Janice Duggan. I'm going to say at this point, thank you to our presenters for this presentation, as well as for all those involved in preparing the presentation and the behind the scenes work and to pulling it all together. It's greatly appreciated. It is an opportunity for the college to connect with employers and to share about information that employers need to know with regard to their teaching staff and their duties and whatnot under the Ontario College Teachers Act. And it's also an opportunity for us to hear back from employers about how we can be of assistance to you. So thank you for joining us today, and we're grateful to see you and look forward to continuing working with you into the future. Thanks, everyone.